FK Consulting and Agent Aid presents. Good day, and welcome to this online course explaining duties applicable to all property practitioners, general ethics. This section is extracted from Regulation No. 45735 of 14 January 2022, as gazetted, and corresponds with Section 34.2. This section is applicable to all property practitioners as defined in the Property Practitioners Act, irrespective of industry. 3/1, 34.2.1. In terms of a property practitioner's general duty to members of the public and other persons or bodies, a property practitioner, 3.1.1, 34.2.1.1, shall not in or pursuant to the conduct of his business do or omit to do any act which is or may be contrary to the integrity of property practitioners in general. 3.1.2, 34.1.2 shall protect the interests of his client at all times to the best of his ability, with due regard to the interests of all other parties concerned. 3.1.3, 34.2.1.3 shall not accept a mandate if the performance of the mandate requires specialized skill or knowledge falling outside his field of competence, or he has not completed the required qualifications unless he will, in the performance of the mandate, be assisted by a person who has the required skill or knowledge, and this fact is disclosed in writing to the client. 3.1.4, 34.2.1.4 shall not in his capacity as a property practitioner willfully or negligently fail to perform any work or duties with such degree of care and skill as might reasonably be expected of a property practitioner. 3.1.5, 34.1.5 shall comply with both the Act, these regulations, and all applicable bylaws, and 3.1.6, 34.2.1.6 shall not through the medium of a company, close corporation, or third party, or by using such company as a front or nominee, do anything which would not be permissible for him to do if he were operating as a property practitioner. 3.2, 34.2.1.7 a property practitioner, 3.21, 34.2.1.8 shall not solicit or influence any person entitled to trust funds under his control to make over or pay to the property practitioner, directly or indirectly, any interest on money deposited or invested in terms of Section 54(1) or 54(2) of the Act. 3.2.2, 34.1.9 shall, before he receives any money in trust in respect of a contract of sale or lease, disclose to the parties concerned that unless they agree in writing to whom interest earned on such money must be paid, the interest may accrue to the property practitioner's fidelity fund, and 3.2.3, 34.2.1.10 shall, if any money is invested by him pursuant to Section 54(2) of the Act or pursuant to an instruction by the party entitled to the interest on money held in trust by the property practitioner. 3.2.3.1, 34.2.1.10.1 invest such money at the best interest rate available in the circumstances at the bank or building society where he normally keeps his trust account or accounts, and 3.2.3 34.1.10.2 pay the full amount of the interest which accrued on the investment to the party entitled to such interest. 3.3, 34.2.2 no property practitioner shall, without just cause, divulge to any third party any confidential information obtained by him concerning the business affairs, trade secrets, or technical methods or processes of a client or any party to a transaction in respect of which he acted as a property practitioner. Important notes on this section. This section of the Code of Conduct gives a general standard of conduct for all property practitioners to adhere to, where such conduct is not specifically regulated elsewhere. It is intended to act as an umbrella section to convey a general rule of thumb for the conduct of property practitioners in cases where the rest of the Code of Conduct does not make mention of a specific topic. Dishonest or corrupt conduct, recklessness in business affairs, and indifference to duty constitute contraventions contemplated by this section. The interests of a property practitioner's client are of utmost importance, and it is the property practitioner's duty to protect their client's interests to the best of their ability, while sticking with the other rules presented in the Code of Conduct. The Property Practitioners Act and any other act or regulation applicable to property practitioners, while this clause places no absolute obligation on the property practitioner to protect the interest of the non-client, the property practitioner must have due regard to such person's interests. Property practitioners may not offer or accept a mandate to offer any service if they do not have the qualification or skill required to perform such service. This means that, for example, a candidate property practitioner may not perform any service as a property practitioner without the mentorship and sign-off by a full-status property practitioner. A property practitioner may also not offer a service such as valuations on a property unless a qualified valuer is contracted to do so. An estate agent may, however, offer an evaluation of comparative market analysis to a potential seller. Property practitioners must ensure they perform their work duties with skill and care, and uphold the highest standard of conduct while performing such duties. For example, when a property practitioner is facilitating the sale of property, they must ensure all documents as required by law are completed and supplied in such a way that they are legally compliant. A property practitioner may be found guilty of improper conduct should a contract document completed by the property practitioner later be found to be null and void because it had not been correctly completed. Property practitioners are expected to comply with all acts, regulations, and bylaws that govern their industry and business dealings. This means that property practitioners are expected to familiarize themselves with the bylaws of the municipal area in which they operate and all acts and regulations such as the FIC Act to ensure that they comply with the rules applicable to them. For example, in the city of Chuan, all show boards must have a COT stamp on before they may be placed in public. Property practitioners may not offer their services as a property practitioner under the guise of a company that is not expected to comply with the Property Practitioners Act. For example, if a property practitioner has a cleaning business, they may not offer property practitioner services while trading as the cleaning services. There must be a clear distinction between their property practitioner activities and any other business they may be involved in. The property practitioner must disclose the position regarding the payment of interest earned on trust monies to the parties concerned before those monies are received in trust. Property practitioners must disclose in writing to whom interest on trust monies shall accrue. There are two options in this case. The interest on trust monies may accrue to the client to which the trust monies belong, or they can accrue to the property practitioner's fidelity fund. Trust monies must also be invested at the best interest rate offered by the business property practitioner's bank. Property practitioners may not disclose any details of their clients or any transaction to a third party. Property practitioners are expected to keep all information in relation to clients and transactions confidential. The Protection of Personal Information Act details how client information should be kept safe. This online learning experience was delivered to you by ETD College. Thank you for attending, and we will see you in the next lesson.